Calling this meeting to order, and so if anybody's out there watching on TV waiting to see us come in, we are in, we're ready, we're waiting for you. And with that, the subcommittee will be at ease. All right, Senator Jones. All right, the first members will take attendance so we can see that we have a quorum. And the clerk will close the roll. The quorum is present. All right, Senator Jones.
Thank you, Mr. Chair, members of the committee. It's good to see so many of you. And then again, my condolences on the loss of Delegate Knight. So I just want to say that. Was that? I'm sorry. I'm just a pastor, just trying to get through life, loving everybody. Mr. Chair.
Move to PBI.
Yeah, PBI. Okay, that's fine. No, Bill 725 is really straightforward. It's an increase to the Technology Trust Fund fee from $5 to $8 per civil filing. It's something that hasn't been touched in decades, and we're just trying to allow them to keep pace from a technological standpoint. It reallocates the fee to strengthen modernization efforts, and that I would hate to belabor the point and just go through all these wonderful talking points that my staff put together. But again, Mr. Carlos Hopkins is here on behalf of this group in this area if you want to hear from him. But again, it just simply, in essence, just moves the fee from $5 to $8.
All right, any questions from members of the subcommittee? Anybody here to speak in favor of the bill? Mr. Hopkins?
Mr. Chairman, members of the committee, Carlos Hopkins with Gentry Law on behalf of the Virginia Court Clerks Association. And as the patron said, and we thank you for bringing the bill, it basically updates the technology fund, the fee that's associated with the clerks. The fee has not been changed since 2004, as we all know, before the first iPhone even came into existence, and it's separate from the Supreme Court Technology Fund. So this assists the smaller jurisdictions with their technology needs. And so for that reason, Mr. Chair, we'd ask that you support the bill. It was currently changed. It's currently $5 now. This would increase it to $8. And instead of the $1 that would be used for the additional technology support, it would be $2 going to the clerks. So with those changes, we'd ask for your support. Thank you.
What are they doing with the fee that they got? Because right now they've come to tell me that they can't do e-wills and that they can't do a whole bunch of things.
Mr. Chairman, I will say with respect to your House bill, we have no position on that bill. In fact, the only thing we requested was a delayed enactment. That looked like a fist fight that we were not involved in. But as to what they're using the fee for, the comp board allocates it, and they use it to support the technology needs of the smaller jurisdictions to allow folks who utilize the court system greater access through technology. And that was the original point was for land use records, and this bill allows it to be used for other technology needs, because as we know, the cost of technology has increased significantly since 2004.
Yeah, so quick question, Mr. Chair.
Senator, Delegate Sullivan, whoever it is.
I think you answered my question, Mr. Hopkins, but because there's a lot of stuff crossed out and then some new words, it is changing what they can spend the money on.
It gives the comp board the ability, based on the needs of the jurisdictions, to provide for additional technology needs. Yes, sir.
Thank you.
All right. Any other questions? My only comment is I'm also mad that I got another bill that would have prevented you all from double charging for all these multi-use documents, and that died in the Senate as well. So it seems like you got plenty of money because you just charge 3 times for every document. You collect that technology fee 3 or 4 times on the same document. But anyway.
Mr. Chair, if I could, that's why there's also in this bill where they need to provide a report by the end of the year. I think they have until December 1st, 2026. So we can see, do they have this slush fund? Is it something that that they're just, flush with cash? But we don't believe that's the case. They're not able to use it on personnel costs or anything of that nature. It's just purely tech-driven.
All right.
Move to report, unless you're so mad you don't want me to.
Sorry. So moved and seconded the bill report. I'll just vote no. Clerk will open the roll. Clerk will close the roll. Bill reports 5-1.
Thank you, Mr. Chair. Members of the committee.
Angry delegate. Senator Rome.
All right. Thank you, Mr. Chair, members of the subcommittee. Mr. Chair, members sub, this is SB 345. All of you, except for our newest member here, had to deal with me dealing with the guardianship bills for a long time. Less so for Delegate Ballard, although he had to a little bit, but the rest of y'all, yeah, you did. So good to see a lot of you, and here we go again.
Welcome back.
Yeah, right. So here's the issue that we're trying to solve with this. So my constituent Yolanda, y'all remember her, for those of you who dealt with this before, her sister died in a horrible guardianship case that was terribly wrong. And we filed and we got the JLARC report that came afterward. We implemented some of the recommendations from that. We had a long back and forth, I know, Delegate Leftwich will remember very well, which we did with making sure that guardians were actually visiting their wards, and we finally got that done, and that's been good. Now, here's the issue that we have. What my constituent is asking is basically that family members who come before the court have the right to petition for jury trial and have a right to petition for an attorney on the respondent's half here, if that person is incapacitated. The issue that has come up from when we talked with Vela, for example, is they say, well, if you do this, then the issue that you're going to have is, will that mean that someone who is not the respondent or is directly responsible for the respondent going to be in charge of deciding whether that person gets an attorney who is loyal to the respondent or is going to have a jury trial if that's not necessarily the best thing for the respondent, right? And so we've been trying to really deal with that issue in this legislation here. And I guess I kind of want to get at here is I want to get into a bit of a dialogue with the subcommittee to figure out whether you all think that having the bill as is, having it so that it includes a party could be able to request jury trial and an attorney, it works, or if we do as my constituent asked for, which is basically to make sure that immediate family as described here has the ability to make that request.
All right, so that's a question from the patron. It's a little unusual.
Yeah.
All right, anybody in the subcommittee want to react to that? Delegate Ballard, and
Thank you,
then
Mr.
Delegate
Chairman.
Sullivan, then
Thank you, Mr. Chairman. So probably
Carney
a question
after
for Council, Britt. Is there anywhere else in the code that a non-party to proceedings can request a jury trial?
Well, so Mr. Chair, Delegate Ballard, I think the nuance here is it actually states that this person would become a party to the proceeding and then would be able to request. So they essentially wouldn't be a third party. They would be party to the case under the bill.
That's right. And Ms. Chair, the reason I put it to the sub is guardianship issues in particular, this is really complicated stuff. And if you get it wrong, people die. And if you get it right, you actually save lives. And this is one of those things where it's like, I don't want to come in here and pretend that I have every answer in guardianship. I'm trying to represent my constituent while at the same time making sure that we have the best outcome possible.
so I'm not sure I understood. Delegate Sullivan, did you have a question?
Yeah, I did. What is it about well, first of all, for council. Council, we're not creating a new jury trial issue here, right? No.
No.
So what is it about asking for a jury trial? Why are you specifying asking for a jury trial? What you really want is for someone to be able to make all decisions relating to the litigation, don't you, isn't it? Which would, seems to me, would include asking for a jury trial or deciding on whether to send out interrogatory, all the things that go with the trial. Why are we highlighting the jury trial decision?
Oh, that, Mr. Chair, I can respond to that. So, Mr. Chair, the reason for the jury trial part on here is my constituent in particular, what she believes that there would have been a better or different outcome had the default only to bench trial not been the only thing that was on the book right now, and that if she, in her capacity as sister to the person who ended up dying, if she had been able to request jury trial, she thinks that at the very least it couldn't have been worse than what the ultimate outcome she had.
So we are adding a jury trial to a proceeding that's usually not a jury trial? That seems to be what Senator Rome is suggesting.
So the respondent under current code does have the right to a jury trial. They can request it. So in current code 642-2007, which is one of the sections that's being amended, the first line says the respondent is entitled to a jury trial upon request and may compel the attendance of witnesses. So the respondent can currently request a jury trial. That's current law.
Mr. Chair, to kind of explain here, the issue that comes up is if you have someone who's incapacitated or if you have someone who only in this case will respond and verbally speak to a family member who can make that request. The issue that you can end up having is an incapacitated person who has not been deemed incapacitated yet to have someone else making the request for jury trial.
So I'm just making sure I understand. So you've got somebody who's saying that, I'm the only person that understands this person. They won't speak to anybody. They'll only speak to me. I'm the only person who understands them. And that doesn't raise the hairs on the back of your neck at all?
Mr. Chair, my response to this is if you had talked with my constituent Yolanda in this case, she would tell you that her sister basically just did not speak to, she was largely nonverbal. And at that point, like, she could understand her. This is, I would say, Mr. Chair, that this is not isolated for if you know people who have significant disabilities and their ability to be understood. That family members very often are someone who understands references that person make that might not be clear to everyone else, or if their speaking style is not the way that someone who has all their typical functions presents, they might still be able to understand that.
Okay, Delegate Carnegie.
So right now, under the code, the counsel for the respondent can request the jury trial on behalf of the respondent. And so would it be easier to just say that any of these individuals can ask the court to appoint counsel for the respondent? Because my concern would be that, let's say the power of attorney wants to be the guardian, someone's contesting that. Now the power of attorney doesn't have the right as a party to ask for a jury trial for themselves under the code. But they can say, well, I'm the guardian, I'm the power of attorney for the ward. I think she needs a jury trial, which then causes more issues, creates a bigger issue.
Mr. Chair, I would tell the delegate that my constituent, what she's told me about this is, she said that the bill must include that family member or power of attorney may hire an attorney or request the judge to appoint one. That's pretty much the ask coming from the constituent.
Yeah, so I think that if they ask the judge to appoint counsel for the respondent, the judge can then ask the guardian ad litem to weigh in and appoint independent counsel, and that who can then request the jury trial. I think that makes sense.
Mr. Chair, do you think that's workable then?
I think that's what the bill says, right? I mean, isn't that what we see on lines like 15 through, let me counsel. Doesn't that kind of described in the first section of the bill?
Yes, Mr. Chair. So where the respondent is unable to communicate, the person, the family member or the power of attorney, and then if you can continue on line 20, may request that the court appoint counsel for the respondent. So I think that that's already in the current bill. We can tweak it otherwise, but I think that immediate concern is already existing in the bill.
And Mr. Chair, if the bill is to report out to full, if anyone flags an issue between now and full and you need me to bring an amendment to clarify that, I'm happy to do that.
Gotcha. All right, Delegate Sullivan.
Thank you, Mr. Chair. So I gather your constituent, it was her sister she was trying to help.
That's right. Mr. Chair, that's correct.
So that's the case from which this this bill is born, but it's going to apply to lots of different cases, including families where there might be more than one family member. And what happens if family member A thinks we ought to do one thing and family member B thinks we ought to do another thing?
Mr. Chair, I would tell the delegate first I would defer to council to make sure that there isn't an existing precedent or code that might be missing.
I don't believe so. We do have the immediate family member definition cross-referenced to the people that
huge
get
definition.
notice. It's quite broad, yes.
Brothers and
So it is possible that potentially people wouldn't agree on what to do with the respondent.
So then, Mr. Chairman,
we can all claim under this statute to have the ability to make the decision. Right?
Under though, if
Turn
they're,
your microphone. Delegate Carnegie.
if they're all just, if they're able to say, judge, appoint counsel for the respondent, and then the independent counsel, who's not, nobody's hired except for the court's appointed, is the one that makes that call of a jury trial, not the family members. I like the family member being able to ask the judge to appoint counsel for the respondent, and then counsel's the only one that can make the jury trial demand. Does that make sense?
It does, although I still wonder why we're separating out jury trial, because a trial has lots of different decisions to be made.
The code currently says that in guardianships, the only one who can request a jury trial is the respondent.
I understand.
Yeah, and so I think it just builds on that. I think it's been like that for a long time, and family members have tried to request jury trial. I know in my jurisdiction, and the judge shoots them down every time.
So I was jumping for, so Delegate Carnegie, are you saying, maybe counsel, so are you suggesting the first part of the bill is good, with the section 64.2 2006 changes, and that we don't do it, because 64.2 2007 doesn't talk about the involvement of an attorney. I mean, it says the respondent, but we assume by counsel, I bet it doesn't have to be by counsel. And so this is the part of the bill I think that's sort of the heart of it here, is that I guess, how does that work? I mean, how does that work? Is that what this bill's saying essentially, is that any brother, sister, stepbrother can request a jury trial?
I believe that's the point of the bill, yes. So the first section that's being amended is separate than the second, and the second one does give these family members the ability to request the jury trial. The other portions of the trial, like Delegate Sullivan was saying, the compelling of the attendance of witnesses, presenting evidence on the respondent's behalf, cross-examining witnesses, that's not included in the request, it's just the jury trial
And, Mr. Chair.
request.
Mr. Chair, according to the text that you got here was immediate family and code, respondent spouse, adult children, parents, and adult siblings, or if no such relatives are known to the petitioner, at least 3 other known relatives of the respondent, including stepchildren.
So what was that? Is that an alternative definition of family member that you're?
That's immediate family as defined in code.
I got you, I understand. All right. All right. Is there anybody in the audience wishing to speak in favor of the bill? Please come forward.
Hi, my name is Virginia Ferris, and I'm with the Disability Law Center of Virginia. We, first of all, would like to thank Senator Rome for bringing this bill and being a champion for people who are under guardianship or have the potential to be under guardianship. As Senator Rome said, we hear all the time about people with disabilities who have alternative means of communication and may be able to best communicate with a close family member or somebody else who's trusted in their system in a way that they wouldn't necessarily be able to communicate directly with a judge. We think that this bill would be just a really good baseline way to make sure that people with disabilities are more consistently represented in guardianship hearings. And so we ask that you pass this bill forward, and we thank you for your time and your willingness to hear it.
All right, anybody in the audience wishing to speak in opposition to the bill? Anybody online? All right. So committee operates by motion. What's the pleasure of the committee?
Mr. Chairman,
Delegate Ballard.
make a comment. I mean, I kind of understand what you're getting at. I mean, it just seems a little odd or clunky to me about how we're trying to get at it in this bill. I think I'm along the lines of Delegate Carnegie, because the court can appoint counsel or guardian ad litem to act on this person's behalf, right? We all agree with that. And then I guess if you take that reasoning even further, if the family member were trying to communicate with appointed counsel or guardian ad litem, I could see that attorney going, hey, I can't communicate with you because I don't have my client's permission. I mean, so maybe, I'll direct this to counsel. I don't know if you could put that in there versus making that family member a party to the proceedings, but that they're authorized to communicate with appointed counsel, whether that be a guardian ad litem or appointed by the court. I do not like how the mechanics of this is working. But just my 2 cents, Mr. Chair. I don't have any issue with the concept of your bill, Senator Rome, but I just don't like the way this is written.
All right, anybody have any thoughts? I might be more comfortable, Senator Rome, if we just did the 64.2 2006 part. I think that's what Delegate Carnegie was getting at. Yeah. And we don't take the new language that's in 64.2 2007. I know that probably in you and your constituents, you may be gutting the bill to some degree, but I think it's making progress. And then we get an attorney involved, and they'll be able to communicate to them that you want to ask for a jury trial. And it works that way. So can I get an amendment to do a substitute that would just encompass essentially the changes in 64.2 2006? It's moved and seconded. As many as favor that motion will say aye. Aye. All right. Those opposed? So I think that was the part that we had the most consensus on, Senator, and keeps the bill alive and moving forward. Can I get a motion?
Move to report.
Move to report. It's been moved and seconded the bill report with substitute. Clerk will open the roll.
I keep on the regular calendar. Sorry.
Clerk will close the roll. Bill report 7-1.
All right. Thank you, Mr. Chair. Thank you, members. Appreciate it.
Yeah, yeah. Yeah, I told him, just say that. All right, Senator Reeves has SB 753. Senator.
Thank you, Mr. Chairman. You all have heard this bill before. It's identical to the same bill from last year, SB 1421. This bill got delivered to the Boys Graves Conference at the Senate Courts Committee's recommendation last year. Senator Serville wanted to send it over there. I think there were a couple of bills that had to deal with AI that we were trying to group together. The bill is similar to Delegates Glass's HB 851, though it's a much simpler approach to the issue. And I'd asked this committee not to lay it on top of hers because hers goes farther into it, and it wasn't approved by Boyd Graves. And so the goal is to offer protection for folks like recording artists, actors, others whose voice and likeness is their livelihood. And as technology progresses and deepfake AI software becomes publicly accessible, I believe this is a measured way for the state to offer those protections. And I believe many of your colleagues that serve on Boyd Graves believe the same thing. It's not going to create any criminal charges, but instead grant the right to maintain a suit in equity against a firm or individual who unlawfully uses your voice or likeness for commercial or advertising purposes to restrain their use and coverage damages. So it's a pretty simple bill, Mr. Chairman. And again, you all should have a memo from Boyd Graves that says they're good with it.
Counsel, can I ask you a question? Thank you, Senator. Can I ask you, as I read this, we're just adding the words voice and likeness. Isn't that right? To existing statute. What is Delegate Glass's bill? I frankly didn't.
Yeah, so hers does include this portion, Mr. Chair, but it also creates an additional civil liability for a person who produces, distributes, or makes available the digital replica. So she defines it sort of in the synthetic media sense. More AI stuff is involved in that definition of a person's voice or likeness. So hers includes this, but goes much, much further. It also changes the statute of limitations, I think, from 20 to 100 years. And the statute of limitations remains 20 in this bill.
But the two bills are not inconsistent with one another.
They are not, no. Hers just goes further. Hers includes all of his does not include all of hers.
Mr. Chairman, with my bill, I have harmony in the church. I don't believe I would have that same harmony with Delegate Glass. And I love her to death, but I don't know that hers would make it all the way.
Any questions for the senator from members of the committee? Is there anyone in the audience here to testify in favor of SB 753? No one. Anybody here in opposition? The motion to report properly second. Any further discussion from members of the committee? All right. Clerk will please open the roll. Senator, the bill reports by a vote of 6-1.
Thank you very much. Thank you, guys.
No further business. We are adjourned.